Now back to the show. This is The Law Show on CL 650.
Welcome back to the program. Nice to have you along with us this morning. On today's episode of The Law Show, Scott Stanley and Steve Gibson from MurphyBattista, LLP, Vancouver personal injury firm, downtown at 650 West Georgia on the program. And Steve, you mentioned this earlier. You were talking about surveillance as an enforcement method, perhaps, when we were discussing ICBC earlier. Can you expand on this whole notion of surveillance? Because it's something that, well, you can't go anywhere in public, anywhere in British Columbia now and not be on camera. And if you actually expect as a private citizen to enjoy privacy in public, you are seriously deluded. Everywhere you go, you're on camera. Is that what you're talking about?
Yes. Well, let me begin by just commenting that this is ICBC is evolving in terms of how they use surveillance, how they use people's own information against them. And very recently, I think a couple of days ago, I think there was an article where ICBC commented that they are reducing their investment in hiring private investigators, human intelligence, and they're now going more digital and using
cyber sleuth.
Cyber sleuthing, exactly. And this is where we get into the whole concept of using people's own information against them.
So now we're talking social media.
Social media. So people's widespread use of Facebook and Twitter, and there's just so many different social media
Instagram,
websites.
all of those, you bet. Yeah.
You know, and tends to be the younger population that heavily rely on this, but it's really being utilized quite in a widespread manner by ICBC. There was a recent case that just came out from our BC Supreme Court. And a young woman was alleging a chronic pain type of situation. She said she was a social hermit, that she wasn't able to function in her activities.
I assume as a result of an accident,
As a result of an accident.
Okay, all right.
Saying her life was completely altered. And what happened was she had her own Facebook, and it had a very high privacy settings, so she thought, well, this is my own personal information. The defense, ICBC, got a court order that the veil would have to be lifted on the privacy settings, and they had to produce everything
on this person's
for a number of years.
Facebook page.
Exactly.
Okay.
And so basically, ICBC was given free rein to review the entirety of the Facebook, and it really hurt this woman because she completely contradicted, at least what was in the Facebook, completely contradicted what she said in court about her physical, emotional health, how it was affecting her work. For example, give you one example.
Okay.
She was alleging that she really wanted to continue being promoted within the job that she had, and that she loved the job and she really wanted to do better than she was able. She was alleging physically she couldn't do this job.
Right, okay.
Well, in the Facebook posting, she kept talking about how she hated this job, and I mean, she didn't want to go to work, and like just completely diametrically opposed to what she said in court. And I mean, deservedly so. I mean, if she's posting that kind of information, I mean, you cannot expect that. I mean, it is still a public service. It's not like rummaging around in your home, but when you put something online, the courts are willing in certain circumstances to allow access to what you think is very private information.
So in a very 2015 context, this young woman was hoisted up by her own petard.
She was.
to use a very old expression, correct? I mean, really,
exactly.
Sunk by your own cannonballs, literally, right?
And, and if it's true, and, I wasn't involved in this case,
of course,
and
right,
I wasn't there during the trial, but if it is true and she gave that kind of evidence in court, and it's that diametrically opposed to what she was actually living, and she was partying and drinking and having a lot of fun, it just didn't sit right with the medical evidence that was being presented. So that is a case where exaggeration comes into play,
and so she lost.
She got tagged, and
right.
Potentially rightfully so. I don't know the case, and I don't want to comment on her integrity.
Right,
but,
right.
But that's
on the face of it, she really did sink her own boat, didn't she?
The judge did not accept her evidence.
Scott?
Yeah.
Well, I think judges will understand that if someone's injured, they're out socializing, they're partying, right? If you're not going to have, I think they will accept that people aren't going to be a hermit.
Right.
The problem is if you say you're a hermit, you never go out. Never, ever, and always are words that people in ICBC claims should always avoid using, because when you say never, it means never. And so you need to be very...
And one occasion is no longer never.
Yeah,
right?
So you have to be very careful about how you describe what your life is like. And I think the courts will accept that people they have good days and bad days, but one thing they have little tolerance for are people that lie.
Right, right.
I mean, I had a case where a young girl no doubt she had a brain injury, and then after that she became a sex trade worker. And it went to trial.
A brain injury again, Scott, resulting from a car accident?
Right.
Okay.
Right. So she had a frontal lobe brain injury, which affected her judgment. It made her sexually impulsive, and she became a sex trade worker. And the issue was, well, would she have become a sex trade worker anyways? And what the defense and the insurance company did in that case is they went back and looked. She was 17 when this accident happened. And so they went back and looked at all her Twitter posts between age 15 and 17. And they said, well, look, she was sexually promiscuous, and and therefore she probably would have been a sex trade worker anyways. Well, most girls when they're 15 and 17, they're exploring their own sexuality.
I was just going to say they're at least curious, if nothing else.
Yeah, and they're going to post some things that I think they might regret later on if they were to go be confronted with that information at a job interview. But in the case that I did, I think the judge understood that, look, that's just a kid being a kid and exploring herself, as opposed to someone who's actually saying things that are patently inconsistent with what the evidence they've given at trial.
So how did that case resolve itself?
Oh, very well. The judge found that she did have a brain injury and that her problems were related to that and not some sort of sinister behavior before the accident.
Okay, now both of these cases that you've just described have come as a result of a trial. In one case, the woman lost her trial or her case because of lying, and in the other case, the woman won. Because the Facebook postings were deemed to be irrelevant, basically.
Yep.
So now that's, again, we're talking at trial. But if you are injured and seriously injured, as you mentioned earlier, trial is generally the very last possibility for anyone trying to resolve their differences with their insurance company. So before that trial phase, what other opportunities do injured people have to resolve their differences with their insurer before they sit down with a judge and a jury and the whole gowns and very serious scenario? What do they do, Scott? What possibilities are there?
Well, generally, if a claim is before it gets to trial, there's going to be some negotiation, and that can be formal, meaning or informal, meaning the lawyers, send a letter off. They battle like the poet laureates that we try to be. So we'll send a settlement offer back, and the defense will send a response. That used to be the way it happened. So you'd basically send a letter. 2 weeks later, you'd get a response, and it really was an inefficient way to try to settle a claim, because you'd send a letter and you'd forget about it. And what came about in, say, the mid-90s is mediation became very popular in ICBC, where the
elimination of the letters.
Right.
And
everybody would just commit to a day where we're going to see if we can get this thing settled. We're not going to be distracted by the phones or anybody else. We're going to just get in a room with an independent mediator, and we're going to try to settle the claim.
Okay.
And so most cases of any significance will go to a mediation. Now, and then failing that, it goes to trial. Now, ICBC's really cut back in the number of claims they want to mediate. And I think for good reason. A lot of claims that were very small claims, they were incurring the expense of a mediation unnecessarily.
Okay.
So those are the basic steps you get before you go to trial.
So mediation, no, is that because it is an important step before trial, Steve, are most cases resolved during the mediation process rather than the trial phase, the next big step?
I don't know what the overall statistics of success are with mediation. We tend to settle maybe half of them at mediation, and the reason, I mean, that's a pretty decent percentage.
Yes, it is.
The reason it does work to some degree is because everyone tends to be focused on trying to get it done. Now, the caveat to that is that very often ICBC, they will go away and do a committee where they get authority to settle for a certain number before they even come to the mediation, so they haven't even heard yet what the plaintiff is going to say.
And they've already written a check, so to speak.
They've already figured out an amount,
Right.
and very often that is insufficient.
Right, right.
So we don't settle, and then they go away. It doesn't mean that's the end of it, and then your only option's trial. Very often, the information that they get from a mediation can be helpful. The defense lawyer and the examiner will go back to ICBC, share more information, and they can get further authority. So there can be further negotiations, and most cases do end up resolving out of court, but sometimes they don't.
Scott, one thing that you and I have discussed in previous meetings on the radio is the fact that at Murphy-Battista, you occasionally take over a case that has been handed to you by a client who's moved on from their last lawyer. It didn't work out right, perhaps after the mediation phase at which the representation wasn't aggressive enough or whatever. Does that happen fairly regularly when a person comes to you and says, look, the last guy was maybe a good lawyer for writing wills or real estate or whatever, but this is serious, and I want my life back, or I want some serious compensation. He or she was incapable of doing the job.
Yeah, I think about 30% of the cases that I have are cases that I take over from other lawyers. And they typically come after there's been some negotiation. Usually the client has been told or advised to settle. And it's not as though the lawyers have not been sufficiently aggressive. I mean, a lawyer being aggressive is not a good thing. It actually should be discouraged. But what happens is that I think the lawyers just don't really want to go to trial, or they're not comfortable going to trial.
Right.
And they don't really tell the clients that, or sometimes they do. They just say, I don't really want to take your case to trial. But the clients get the sense that there's more there. Clients are quite smart, and they just want to get a second opinion if it's something significant.
Sure.
And then, some of the times they say, well, look, the work the lawyer's done, the offer that's on the table, I think it's fine. I don't think I'm going to do any better for you. You should accept it. But there are times, I think more often than not, I think, look, I think there's more to this claim. Something may have been missed. The lawyer perhaps didn't investigate something. Let's take it on and see what we can do with it.
Well, if you're in a serious medical situation and you go to your doctor and the doc says, well, this is what's wrong, and you go, gee, I don't think so, I'm going for a second opinion, that's considered okay. So for the person to do the same thing with a lawyer should also be considered as okay as seeking out a second medical opinion.
I assume that every one of my clients is going to get an opinion. Second opinion. I don't know if they do or not. I've never had a client fire me. So
I had a trial that was going to start just this past Monday for 3 weeks, and on Friday I resolved it for a sum that was 6 times greater than what the previous lawyer before me had been offered and had recommended to the client. So, sometimes you have to take it either all the way or right to the courthouse steps.
So if you find yourself in that sort of odd predicament where you're injured, you have retained legal counsel, you're moving forward, but it's not going your way, it's not going at your speed, it's just not going the way you thought it would, maybe that second opinion is quite valid and perhaps even necessary. And remember, that first consultation at Murphy-Battista is free. How about that? Steve Gibson and Scott Stanley back with us on The Law Show, and more to come after this quick timeout.
There's more of the show still ahead. This is The Law Show on CL 650.